all due respect, and like I said, I don't have anything personal against this court. And I'm not a corporation, right? I'm a natural person. Where is the body of the crime? You went to law school, you're a practitioner.
No, because I haven't heard.
This might be one of the most difficult courtroom appearances I've seen from someone claiming to be a sovereign citizen and that's saying something. The man walks in acting like he's above the law, insisting he has a right to travel and doesn't need a driver's license. But what really stands out is how the judge handles it. She stays calm, collected, and completely in control, never raising her voice, just carefully dismantling his arguments one by one. Watching him fall apart in real time is something else. Let us know your thoughts on this one. How do you think he thought this would go?
Supremacy clause of the U.S. Constitution and hold that these state statutes in which they have been charged with are constitutional based on the U.S. Supreme Court. And what is the case? The Cheney versus Winnebago Department of Social Services, there was a young child whom the mother relays that the father was beating the child, and the child died. The mother sued all the way to the U.S. Supreme Court. The U.S. Supreme Court held that no matter how bad or gruesome that this case was, when it concerned the case, that the states have no duty to protect citizens from other citizens. Anything that compels performance, there has to be a contract. And again, I reserve my rights under UCC 1-308 and the common law UCC 1-106. And it's clear, Your Honor. And I ask that this court, do their sworn, fulfill their sworn oath under the Michigan rules, the Michigan Judicial Code of Conduct. The court is not to be swayed by public opinion or what the people may think or whatever. Like the great honorable Judge Dalton A. Rose. So every government is entitled to a Republican form of government, not a corporate. I'm not a corporation, right? I'm a natural person. The case law clearly breaks everything down, which everyone is in default. I just ask that this court dismiss this case at this juncture. If the court does not, I demand under the Supremacy Clause, the subpoena power of this court, to have Ken Worthy brought in so we can have an evidentiary hearing. Because how can a criminal prosecute or allege that I'm a criminal when they're committing all the crimes, Judge? Since I've been home, I've been making reports of police and other things, violations of law against me at the precinct. And no one listens to me. They just ignore me. But when people call and say, well, hey, Mr. McCurry did this, Mr. McCurry did that, they come, then it's found out nothing happened.
Under our state constitution, this court has jurisdiction. Furthermore, as far as discovery goes, I personally sent Mr. McCrary twice, and I have the emails, copies of the emails that show that that's necessary. Dates are not on here. May 24th, which was last week, and May 5th.
He keeps shaking his head like he's innocent, even though it's clear he deleted important emails from the prosecutor. It's like he thinks no one noticed. His beliefs are so deep in this sovereign citizen mindset that you almost have to admire the level of denial. Almost, he's clearly not telling the truth, and his whole attitude just feels off. Still, the way he confidently spouts made-up ideas, as if they're facts, is a classic example of someone who's absolutely sure they're right, Evan, when they're clearly not. What do you think?
I'm just going to take a couple seconds. One of those emails, he is missing.
That's not my fault. They violate your order. That's not.
Okay. So you should have received one of them.
Nothing.
Right, and neither one of them came back and said.
Okay. All right. So, Mr. McCurry, I don't know why you're not receiving discovery. You did not receive.
He didn't send. Can we subpoena Google and litigate this and show that he hasn't
This
seen
is not a
anything?
trial. This is not evidentiary.
Well, can I say one more thing?
After you're done today, primary email address, you can test it to make sure that you receive it.
Well, he did. It showed me that he got my paper. He admitted in the last receipt that he received my
Okay.
paper.
And
So why would he send it? Why wouldn't I get it back? My email is legit. It's my phone right here.
Okay.
Also a jurisdictional challenge.
Before we get to that, Adrian says you want to respond. Yes, Your Honor, I do want to make a record. This defendant has already availed himself to the jurisdiction of the courts of the state by admitting to having a driver's license. I also further add that the 10th Amendment has allotted and given these powers to the state, which then allows the state to create criminal laws under which this defendant must avail himself to. I further add that, again, as the court has acknowledged, that this defendant has at least once received the discovery to his emails, to his correct email. So any more allegations of not receiving discovery would be improper, given that we have it at least proven that he has it at least once. There have been no additions or corrections since the discovery was done the first time.
May I respond? Yeah, just briefly about that. Well, this young lady here, to basically respond to Mrs. Session, to respond to her statements in Michigan, they're locking people up for not having a driver's license. I was compelled, but I reserve my rights. This is what the law. Pardon? Well, I understand that, but what I'm saying is the corpus delicti, they're going off written statements. You know the corpus delicti rule under the Michigan Supreme Court case, as well as the federal court case. Where's the body of a crime? They're saying ammunition, all this, that. Where's the guns at? Where's the victim at? Strangulation, where's all this? Where's the medical?
I wouldn't know because we haven't
then,
had these.
okay, but no, jurisdiction, once it's challenged, it must be proven by the people. This is state and federal law.
Think commitment or just complete confusion. Now, let's be honest, what's really going on here? Is this guy actually confused, or is he pretending just to delay things? There are moments when he sounds like he knows exactly what he's doing, throwing around legal terms and twisting case law, but none of it makes sense. Then he randomly says there's no victim or weapon, even though the trial hasn't even started, and he just won't stop talking. Every time he interrupts the judge, it's harder to watch. At this point, it seems
they're already in default, but still, again, I'm demanding jurisdiction be challenged, personal subject matter, and territorial jurisdiction. Even when I was in prison, I had interactions with Kim Work, chief prosecuting officer of the state. I reserved my rights in prior proceedings, as well as I was compelled to obtain a driver's license, and I reserved my rights. That's all the law mandates, that I reserve my rights, which I have done. And right now, this lady, Mrs. Prosecutor, I can't remember her name, Mrs. Sisson, Esquire Sisson, and this gentleman here, they're in conspiracy and violating federal and state law. They're committing crimes, and I demand that their oath of office, their law, their license to practice law, amongst other things, be given to me, as well as their bond, as well as you, Judge, Your Honor. Also, like I say, jurisdiction has been challenged, and they have to prove it first based on the case law, which I have noted in this paper. They can't get around that. We can say, well, yeah, they're talking about reserving rights and all that. Okay, but still the law from the state Supreme Court, Court of Appeals, and federal jurisdictions clearly mandates that once jurisdiction is challenged, the person asserting jurisdiction has to prove it. And all they have is statements. Under the corpus delicti rule, out-of-court statements is not evidence, so these charges should be dismissed. Where is the body of the crime? You went to law school, you're a practitioner.
No, because I haven't heard that.
Well, that's not how it works with jurisdiction.
That's how. So, do you have any last?
Well, I would like.
Statements?
Okay, I would like to challenge jurisdiction again, which I have done from the onset of this case. Personal, subject matter, and territorial jurisdiction. State and federal case law is clear, in which this court, being inferior to the higher courts, must adhere to their oath of office, their bond, and so on and so forth, their license to practice law, and the Michigan rules of Code of Judicial Conduct, and must compel the people to prove jurisdiction, which they're asserting. Where's the proof? You have to show this court. That's at any stage of the proceeding the law allows.
Okay. So on discovery, I saw paperwork. Department's email address that you provided to the court is not on the record. That discovery was sent. I'm not sure if it was an email. Please don't. If there's another email you'd like to be sent to, I will ask the prosecutor to know.
Two, for requesting license numbers from everyone. My name is right here in front of you. You go right to State Bar.
I ain't saying that.
RP numbers are available to look up as they are for any general purpose.
Seems like he's more interested in hearing self-talk than facing the actual charges. This is exactly the kind of case that slows down the court system. People like this come in with no legal standing and try to argue laws that don't exist. He really believes he's found some legal loophole online, while actual victims sit and wait for their cases to be heard. Judges and court staff have to waste hours on arguments that go nowhere. And the worst part? These folks walk out thinking they made some kind of point when in reality, all they've done is guarantee themselves more trouble. So what do you think, is this real belief or just a way to dodge responsibility?